Have you ever dealt with a homeowners association? You know, the HOA. For some, they're a necessary part of keeping a neighborhood looking nice. For others, they're a constant headache, a source of endless rules and regulations. Well, today we're diving into a story that takes the classic HOA dispute to a whole new level. This isn't just about lawn height or the color of your front door. This is about a massive barn, a determined homeowner, and a legal showdown that went all the way to court. And trust me, the ending is not what the HOA expected. Imagine this. You buy a beautiful piece of land, a little over 5 acres, in a lovely semi-rural subdivision. You've got dreams. You want to build your forever home, maybe have some space for hobbies, and just enjoy the peace and quiet. That's exactly what one couple did. They found their perfect spot, a place with a bit of country charm, but still part of a community. The only catch, it was governed by an HOA. Now, like any diligent homebuyer, they read the covenants, the rules and restrictions that come with living in the neighborhood. They saw the usual stuff, rules about fences, sheds, and general property maintenance. Nothing seemed too out of the ordinary. So, they bought the land and started making plans. Their dream included a large barn, not just a small shed for a lawnmower, but a substantial, 3,600 square foot structure. This wasn't just for storage. It was going to be a workshop, a place for projects, a core part of their life on this new property. They knew they needed approval from the HOA's Architectural Control Committee, or ACC. So, they did everything by the book. They drew up detailed plans for the barn and submitted them to the committee for review. And here's where the first green light appeared. The ACC looked at the plans, considered the location on the large lot, and gave them the thumbs up. They approved the barn. With this official approval in hand, the couple was thrilled. They hired contractors, poured a massive concrete foundation, and started erecting the steel frame. The barn was starting to take shape. It was a huge investment of time, effort, and, of course, a lot of money. We're talking tens of thousands of dollars just to get to this point. Their dream was becoming a reality, right there on their 5-acre plot. But then, the trouble started. As the big red frame of the barn went up, it caught the attention of some other neighbors, and more importantly, the HOA's board of directors. The board looked at the structure rising from the ground and decided they didn't like it. They felt it was well too much of a barn. They believed it violated the spirit, if not the letter, of the community's rules. They argued that such a large metal-sided building wasn't appropriate for their residential neighborhood, even with its larger lots. So, the HOA board did something that threw the homeowners world into a tailspin. They overruled their own Architectural Control Committee. They sent a letter to the couple, revoking the approval they had already received. They demanded that all construction stop immediately. Imagine getting that letter. You've followed the rules. You got permission. You've spent a fortune. And now, the very organization that gave you the green light is slamming on the brakes and telling you to tear it all down. The homeowners were in shock. They had a half-built barn and a legal threat hanging over their heads. The HOA's position was firm. The barn had to go. They believed the ACC had made a mistake in approving it, and that the board had the ultimate authority to correct that mistake. They pointed to language in the covenants that they interpreted as giving them the power to deny any structure they deemed inharmonious with the neighborhood. From their perspective, a giant metal barn was the definition of inharmonious. The couple, however, wasn't going to just roll over and dismantle their dream. They looked at the same set of rules and saw things differently. They saw the approval they had received in writing from the ACC. They saw the clause that said outbuildings were permitted as long as they were of good construction and properly maintained. Their barn, they argued, was exactly that. It was a high-quality, professionally built structure. They believed they had relied on the ACC's approval in good faith. Tearing it down now would be financially devastating. They tried to reason with the board, to find a compromise, but the HOA wouldn't budge. The battle lines were drawn. This is where things escalate from a neighborhood disagreement to a full-blown legal war. The HOA, convinced they were in the right, filed a lawsuit against the homeowners. Their goal was simple, to get a court order forcing the couple to tear down the barn at their own expense. Can you even imagine the stress? You're trying to build a home, and instead, you're hiring lawyers and preparing for a court case against your own neighbors. The case went to trial, and the core of the argument boiled down to one key question: who had the final say? The Architectural Control Committee that gave the initial approval, or the HOA board that later revoked it? The HOA's lawyers argued that the board had ultimate authority over all decisions, including those made by its committees. They claimed the ACC's approval was a mistake, an error in judgment that the board was entitled to correct to protect the overall aesthetic and property values of the neighborhood. The homeowners' legal team countered with a powerful argument based on a legal principle called estoppel. In simple terms, estoppel prevents someone from going back on their word when someone else has relied on that word to their detriment. Their argument was straightforward. The HOA, through its designated committee, gave us permission. We relied on that permission and spent a significant amount of money. It is fundamentally unfair for the HOA to now change its mind and cause us such a huge financial loss. They presented evidence of the written approval, the invoices from contractors, and the timeline of events. They showed the court that they had acted reasonably and in good faith every step of the way. The judge listened to both sides. It was a classic case of contract interpretation and fairness. On one hand, you have the HOA's desire to enforce its rules and maintain a certain look for the community. On the other hand, you have a homeowner who followed the established procedure and was now facing a catastrophic financial blow because the organization changed its mind. After considering all the evidence and legal arguments, the court made its decision, and it was a decisive victory for the homeowners. The judge ruled in their favor, finding that the HOA could not force them to tear down the barn. The court's reasoning was centered on that principle of it agreed that the homeowners had a right to rely on the official, written approval they received from the Architectural Control Committee. The court stated that it would be unjust to allow the HOA to revoke its approval after the homeowners had already acted on it and invested so much money. The HOA had created a process for approvals. The homeowners followed it, and the HOA had to live with the outcome. The initial approval, once given and acted upon, was binding. The board couldn't just come along later and say, "Oops, we changed our minds." The half-built barn was there to stay. This ruling was a huge relief for the family and a major blow to the HOA. Not only did they lose the case and fail to get the barn removed, but they were also on the hook for their own significant legal fees. Lawsuits are incredibly expensive, and this failed attempt to bully a homeowner ended up costing the entire community. It's a powerful reminder that an HOA's power is not absolute. They have to follow their own rules and procedures, and they have to act fairly. So, what can we all learn from this? First, if you're a homeowner in an HOA, read your documents carefully. Understand the process for getting approvals. And if you get an approval, make sure it's in writing. That piece of paper can be your most valuable asset. Second, this case shows that you can fight back. It takes courage, resources, and a good legal team, but you don't always have to back down to an overreaching HOA board. And for the HOAs out there, this story is a cautionary tale. Having clear, unambiguous rules and consistent enforcement is key. Overruling your own committees without a very, very good reason can land you in legal hot water and cost your members a lot of money. It's a lesson in fairness and respecting the procedures you yourself have put in place. In the end, the big red barn stood tall, a symbol of a homeowner's victory against a powerful HOA. What do you think about this case? Was the HOA out of line, or did they have a point about the barn? Let me know your thoughts down in the comments. I read every single one. Thanks for watching, and if you enjoyed this story, be sure to hit that subscribe button for more deep dives into fascinating legal battles. See you next time.